Hi, I'm Katie Phang, and this is Adam Klasfeld, who really doesn't need an introduction because he's the most amazing person. But please subscribe and support Adam and his hard work that he's doing at All Rise News. I am going to straight out of the gate tease that Adam is going to be in person where next week?
At Judge Dugan's criminal trial in Milwaukee, Wisconsin.
For those of you that have maybe forgotten and needed the reminder, because it really has been one of those years, Judge Hannah Dugan in Wisconsin was one of the very first, I think, Adam, if not the first, who was a political persecution target from the Trump administration, a sitting judge to be indicted and prosecuted, um, which is wild in my brain to wrap around. But Adam will go in person to be able to cover that very important trial of Judge Hannah Dugan. And so, again, part of that ability for Adam to be able to go and do that and to give support to people like me that want to know what's happening in real time, boots on the ground, is you providing support and subscriptions to Adam Klasfeld and his newsletter, All Rise News, his Substack, which I'm very proud to say is rising right now very quickly on the news. So, Adam, thanks and for covering that. I'm so glad that you're doing that. So let's get to the breaking news. We do have a 24-page order that has been entered, an opinion and order that was filed and entered today by a federal judge in the Southern District of New York. This is Judge Paul Engelmeyer. Is it Mayer or Meyer? Do you know?
Engelmeyer, yeah.
And so Judge Engelmeyer is the judge who was not the presiding judge over Ghislaine Maxwell's trial, an initial indictment and superseding indictment, but is the judge who has been ruling on subsequent motions that have been filed, including the attempts by the DOJ to unseal the grand jury records. And I appreciate Judge Engelmeyer entering this 24-page opinion in order that Adam and I are going to talk about right now, because I thought it was yet again an incredibly thoughtful, detailed explanation of why the grand jury records are now going to be unsealed and released in the Ghislaine Maxwell case in the Southern District of New York. So, Adam, get us caught up on the latest on this.
So, first off, thank you for that very generous introduction, Katie. About Judge Engelmeyer, and of course, everyone who's tuning in, Katie Phang also needs no introduction. About Judge Engelmeyer, this ruling was a long time coming. As you noted properly, he did not preside over Ghislaine Maxwell's trial. That judge, Judge Allison Nathan, is now a Second Circuit judge. So she got a promotion. He is handling the remnants of the docket, and that includes the grand jury investigation unsealing fight. Now, you might be thinking right now, we've been here before. This is when the Trump DOJ decided, when people were clamoring for the Epstein files, they said, let's go for these difficult to release grand jury records. It might be a good, in the words of Judge Engelmeyer, diversion from the actual transparency that they could produce. Then Congress demanded the release of the files in the Epstein Files Transparency Act, and then tried to revive their effort to unseal the grand jury materials. So the Trump DOJ succeeded in that effort today, but it is something of a Pyrrhic victory, because that 20-page ruling that Katie Phang was holding up a moment ago also had some other things to say. It had things to say about the nature of the records that are going to be unsealed. He has said before in the first round that don't expect lots of new revelations from these grand jury records. This is essentially an FBI agent restating and summarizing the allegations against Maxwell that came out at a public trial. He went out of the way to say that Trump's DOJ has been misleading both the victims and the broader public about the nature of the files. I see that both of our copies of this ruling are highlighted. I will let you give your highlights first before I go into it. But it's a scathing ruling. It's a bit of a Pyrrhic victory for Trump's DOJ, because yes, they win the release of the files, but he is taking precautions that they do not use this grand jury fight as an excuse to avoid real transparency over the Epstein files. And with that, yeah.
Oh, go ahead. Sorry. No, I was
No,
just
I
going to
was
say
just
a
handing
lot
it
of
over to
people.
you.
A lot of people are asking why now. And so I really wanted to underscore something because, Adam, you and I had walked through the previous ruling from Judge Engelmeyer as to why the grand jury records were not being released. There's a federal rule that actually governs grand juries, and there is a presumption that militates towards maintaining confidentiality and secrecy in grand juries. Let's drop a footnote here, Adam, for all of you that are tuning in, which we're very grateful. The following. That's why it's a big deal that we saw prior to Lindsay Halligan being deemed to be an invalid and illegal appointee as the U.S. Attorney in the Eastern District of Virginia. That's why a lot of the activity that was happening vis-a-vis the James Comey indictment and the fact that grand jury records were ordered to be turned over in that regard with transcripts, et cetera, was such a big deal to see those being turned over because there is a presumption of confidentiality and secrecy when it comes to grand jury records. Now, in this instance, there has been a law that has been signed into law, a bill that is now law, right? And that law, the Epstein Transparency Act, right? That now basically has addressed the secrecy of the grand jury records concerning Jeffrey Epstein and Ghislaine Maxwell specifically. And Judge Engelmeyer makes it clear in his order that Adam and I are walking through with you all right now that Transparency Act, which is now a law that requires the DOJ to turn over certain records concerning Epstein and Maxwell, that there is a huge breadth to the language of that law. It says all records, right? All being underscored. That includes these grand jury records and materials for Epstein and Maxwell. And because this law is now a law, it actually kind of trumps, no pun intended, the grand jury rule when it comes to Epstein and Maxwell specifically. So I want to make sure people understand. Grand jury secrecy still applies. But in this instance, because there's a law that kind of dealt specifically with Epstein and Maxwell, that's why Judge Engelmeyer was saying we are going to authorize now the release. And there's certain caveats as to how it's going to be released. But I just wanted to make sure people understood that, Adam, because a lot of people are asking why in the world did the judge agree to do this? And another thing that Adam said in passing a couple of minutes ago is very important is the judge in his scathing decision not to release it previously, but also in this decision now saying why we're releasing it, underscores the following. And this is why it's such still a diversionary tactic by the DOJ to do this. Judge Engelmeyer on page 4 of this order makes it clear there were two grand juries in Ghislaine Maxwell's case, one that met to return the original indictment and one that met to return a superseding indictment later to add charges. Those grand juries met briefly. They received evidence on a single day. They did not meet to investigate, but to return an indictment only. And the only testimony they heard was summary testimony from two law enforcement officials. And with minor exceptions, the evidence before these grand juries was already a matter of public record, largely as a result of Maxwell's 2021 jury trial. And so, Adam, once again, Judge Engelmeyer saying the breadth, the extent of the stuff that people want as Americans is being held by the DOJ. There's very little that's going to be coming out from these grand jury materials.
That's absolutely right. As a matter of fact, he quotes himself in his prior ruling in a footnote on page 20, where he says, a member of the public familiar with the Maxwell trial record who reviewed the grand jury materials that the government proposes to unseal would thus learn next to nothing new. The materials do not identify any person other than Epstein and Maxwell as having had sexual contact with a minor. They do not discuss or identify any client of Epstein's or Maxwell's, and it goes on in this vein. And that is just him quoting his prior ruling as to setting expectations that if this is the path to transparency, no, that is a path to diversion. But before that is a footnote to a page where he is scathing. And I'm going to take a little bit of a step back.
Sure.
Because there was, before this ruling came out, one of Epstein's victims, and Maxwell's victims who testified at Maxwell's trial, Annie Farmer, the only victim to testify by her real name at her trial, sent a letter to the court essentially saying that she suspected that this entire process was a way to drop an excuse, that saying if there's a protective order, find a legalistic sounding way to avoid Congress's mandate to release the files. And she asked Judge Engelmeyer and Judge Berman in the Epstein case, if you grant this order, please make absolutely clear that nothing in the order stands in the way, or if you deny this order, make clear that nothing in the order stands in the way of releasing the investigative file, which is where the actual transparency would be. And I'm just going to read a couple of lines from this ruling that allude to that. The victim's concerns regrettably have a basis in fact. This is page 20. In 2 rounds of applications to this court to disclose records, DOJ, although paying lip service to
Yeah.
Maxwell's and Epstein's victims, has not treated them with the solicitude they deserve. It goes on in that vein, but he says at the end of the same paragraph, as this court chronicled in denying DOJ's motion, the motion itself misled victims and the public at large in holding out that the Maxwell grand jury materials as essential to the goal of transparency to the American public, when in fact the grand jury materials would not add to public knowledge. And he granted the request by Annie Farmer to add a little paragraph, a small paragraph that makes absolutely clear they cannot use this order, even if this were an order denying it, which it's not, it's granting it. But they cannot use this order to avoid Congress's mandate for transparency.
Yeah, and look, Adam and I, great minds think alike. Uh, both highlighting an asterisk on that particular language. Judge Engelmeyer not suffering fools and making sure that he's calling out the Bondi DOJ for its lack of sensitivity and, frankly, lack of compliance with what the law and the procedures require to safeguard the identity of victims and survivors of Epstein and Maxwell. Adam, just kind of as a bigger picture thing, I'm grateful that this is the Ghislaine Maxwell grand jury materials. I think that Epstein carries a lot of the weight of the discourse because it's called, for example, the Epstein Transparency Act. But I always like to remind people that Ghislaine Maxwell is just as culpable, if not worse in some regards, when it comes to what happened to the victims and the survivors in this trafficking and the sex abuse. Sometimes she gets a pass because we talk about Epstein so much, right? But I really like that we talk about Maxwell. I want to also remind people that there are 3 different grand juries kind of at issue jurisdictionally. There's the Maxwell one in the Southern District of New York. There is the Epstein one in the Southern District of Florida. And Adam and I will briefly talk about that particular order in just a couple of minutes. But one of the orders that we haven't seen, at least Adam and I haven't seen it, is the one concerning Jeffrey Epstein's case that was in the Southern District of New York as well, that came and that was pending when he, and I will use this language, not Adam, unless you agree with me, Adam, mysteriously died. I'll just say that. I'll use that adverb,
That is
mysteriously died.
fair.
So we have an order concerning Ghislaine Maxwell's grand jury materials in the Southern District of New York. We have one from Epstein in the Southern District of Florida, but we have not yet heard, although I'd be surprised if it was different, frankly, Adam, in terms of result. And then we're going to just kind of look briefly at the 2 things that Judge Engelmeyer has now done concerning this opinion and order. One, the judge has now made a change to a existing protective order that was entered previously in the case and in the litigation. And basically, this protective order was put into place to do what? To protect the victims and the survivors. And so when there was discovery that was being sent back and forth, et cetera, or more really the government to the defense in this case, because it was a criminal case, there were protective orders that were entered in this case to protect the victims and the survivors. The judge in this case saying that the protective order is now being amended just to be able to include language that says that the grand jury materials that were covered by the protective order in this case is now a part of that Transparency Act and must be turned over pursuant to that law. But the other thing that I thought was really important, though, Adam, is the second thing that Judge Engelmeyer does in this order concerning personal attestations by the U.S. Attorney in the Southern District of New York. Why don't you talk about that so the viewers understand what's going on with that?
Absolutely. And it's a very interesting thing he did there. He is making certain that every disclosure will have to bear the signature of the Southern District, District of New York's U.S. Attorney Jay Clayton. That it will not be Pam Bondi, who is also a signatory to these briefs. It will not be Todd Blanche. The buck stops at Jay Clayton. And one thing that is notable throughout this litigation to unseal these documents, it has not had the participation of line prosecutors. So the judge is very clearly making Jay Clayton accountable. There's a passage where he talks about how the Southern District of New York brought this case. One of the key people who was instrumental in bringing that case mysteriously no longer works at the Southern District of New York,
That would
Maureen
be
Comey.
Maureen Comey. Yes, exactly. Uh-huh.
A firing that Jay Clayton has never elucidated anything about, and Maureen Comey is suing for her job back. But the judge, Judge Engelmeyer, has instituted this avenue of accountability and making clear that before they release anything, that Jay Clayton is attesting to the fact that a victim isn't put at risk by the disclosure. A victim isn't that they are following the law concerning every disclosure that comes forward. And it's also worth highlighting that both Judge Richard Berman, who presided over Epstein's thwarted criminal trial, and Judge Engelmeyer had called the actions in the initial unsealing a diversion, the same word used by both federal judges. And that's an incredible rebuke against the man who leads the Southern District of New York. But in a sense, this particular opinion puts more confidence in him than the higher ups at DOJ. It is making sure that the buck stops with him, and we'll see what happens going forward.
Yeah, and in the chat box, in the chat, live chat, Adam R. Henry asking, what's the significance of the Jay Clayton signature? Well, folks, it's because, as Adam aptly noted a few minutes ago, Judge Engelmeyer calls out the Pamela Joe DOJ saying, y'all have screwed the pooch so badly in terms of protecting the victims and survivors' identities in the kind of filings that you have been doing, that you've never even reached out to them when you've asked to unseal these records, and until you guys got called out for it, then suddenly you found Jesus and figured out you got to do it, right? Which is not the proper procedure. So in this instance, because there was a clamoring from the victims and victims' attorneys saying, you know what? We don't mind the transparency, but heck, you got to protect our identities, right? Or at least make some effort. Judge Engelmeyer is saying, you know what? We are going to have the accountability that Adam's talking about. The U.S. Attorney for the Southern District of New York is going to have to, quote, personally certify in a sworn declaration filed on the docket of this case that the records have been rigorously reviewed for compliance with this particular section of the Epstein Files Transparency Act, and that none of the records to be released contain personally identifiable information of victims or victims' personal and medical files, and similar files, the disclosure of which would constitute a clearly unwarranted invasion of personal privacy. This means that the U.S. Attorney, can you imagine how many cases, Adam and those tuning in, how many cases the U.S. Attorney for the Southern District of New York is handling ostensibly as the head of this office? He is now going to have to personally attest through a sworn declaration that he himself has reviewed these records and that none of them violate this law. If I were Jay Clayton, I would poop my pants a little bit here because there would be a presumption of having to go through a lot. But then the other thing, too, is this. I want to remind people, too. Jay Clayton is the guy that Pamela Joe put in charge of investigating the Democrats that are related to or referenced in the Epstein files.
Absolutely.
So I'm just going to give the side eye right now, not to Adam, not to any of you, but we all know what that's all about. Because my concern, Adam, if we can pull on this thread for a second, is
Yeah.
that there is a deadline coming up theoretically in about 10 days that the DOJ must comply with, because this law said 30 days from the date of signing, which was what, November 19th, right? And my concern is one of the exceptions to disclosure is a open criminal investigation. And that's one of the reasons why we may not be able to get all the records that we need.
Right. And to your point about Jay Clayton also had a now infamous interview on CNBC, where he was talking about how the legal community should have spoken up when Donald Trump was being prosecuted. He's someone who, and here's his history within the Southern District of New York. He used to be with the Securities and Exchange Commission. He was a director of that agency. So someone who, he's not a Lindsay Halligan, he's not a Alina Habba, but when Trump was firing a prior U.S. attorney, Jeffrey Berman, the Jeffrey Berman refused to step down in favor of Jay Clayton, who is now leading the office. He said, I won't go unless you put my assistant in my place, because he didn't think Jay Clayton, who had agency experience but didn't have federal prosecutorial experience, was experienced enough for this job. And one line that was also in that part of what you were reading, Katie, this review is to be done by persons including attorneys at the United States Attorney's Office for the Southern District of New York. And I want to talk about that line folks have been talking about with Trump and Epstein, the
Yeah.
dog that didn't bark. The dog that didn't bark in this unsealing case have been the line prosecutors of the Southern District of New York. And I think what Judge Engelmeyer is doing here very deliberately is putting an avenue of accountability. He is dictating that the people who are reviewing the documents that Jay Clayton will have to certify, give his signature in a sworn declaration. The people doing that aren't Main Justice. They are the people who know what will identify the victims, what the relevant documents are. So it's just one more avenue of accountability that I think that Judge Engelmeyer very deliberately is doing. And I would be very surprised if, when the order, to your point, and I agree with you entirely, when Judge Berman, and it's a different Berman, they're not related, when Judge Richard Berman finally releases his order regarding the Epstein grand jury minutes, it will be very similar to this, I expect. Judge Berman, a little bit of trivia, is a licensed clinical social worker. He is very, very responsive to the needs of the victims. He had held an unusual hearing after Epstein's mysterious death, where the victims had a chance to speak. That usually doesn't happen after a case is dismissed because the defendant is dead. And I think that's because Judge Berman was sensitive to the fact that what the need for proceedings like these were, that there needed to be closure, there needed to be a forum for the victims. So I expect he's going to follow in a path very similar to Engelmeyer's.
Yeah, and Adam, I really appreciate the thoughtful kind of note here about the other US attorneys in the office having a part of this record review, right? Because we know that Todd Blanche went within less than a week after Maureen Comey, who was one of the lead prosecutors on the trial team for Epstein and Maxwell, someone who knew the facts backwards and forwards and the evidence of this case. She gets canned. And as you notably, reminded us, she's suing about that. And then less than a week later, Blanche goes down to hang out with Ghislaine Maxwell in the U.S. Attorney's Office in Tallahassee, Florida, plucking her out of that federal pen there, the Federal Corrections Institute there. She's now hanging out with I feel badly for the dogs, like the therapy dogs, and she's getting all of the special perks that, thank God, House Oversight and people like Jamie Raskin and others on Judiciary are really kind of following up and saying, hey, DOJ, you need to let us know why this is happening. But Blanche never, as we saw from the audio and the transcript, Adam, never pressed Ghislaine Maxwell, never truly cross-examined her, partially because he didn't know what the fuck was going on, because he didn't know the
Absolutely.
facts, right? And so in this instance, it's important to make Clayton have to own it, right? Because if he discloses somebody because that office didn't do their job properly in identifying victims and survivors, then I bet you $1,000,000 Engelmeyer is going to lose his shit, because a sworn declaration is under penalties of perjury and is a contempt issue. So you know what? Good for Engelmeyer for saying, I'm going to bake in protections that have not been afforded to these victims and survivors by this Pamela Joe DOJ. And I'm grateful for that, because I think this is a critical part of this order that he didn't have to do. Right? All he had to do was say, comply with the law and the rules. But in this instance, he says, no, I'm going to take it one step further. I'm going to call you out on it, and I'm going to make them actually have to do the right thing by you.
Absolutely. And that's why I call this a Pyrrhic victory for Trump's DOJ, the kind of victory where you wind up destroyed. In this case, with scathing swipes about what you are up to
Yep.
here. In this particular case, the Trump DOJ saying, going along the lines of this being a diversion, I'm going to unseal it, and the public will see that everything I said is true about this not moving the needle. And by the way, any benefit that you thought this method of doing things might have for your ability to withhold documents, I'm going to take that off the table. And I'm going to enforce some consequences should you not follow my order to the letter.
So, just very quickly, guys, I also wanted Adam and I to talk about with all of you that are tuning in right now, and thank you, the more than 1,700 of you that have joined us today in the middle of the day on Tuesday, December 9th. Again, please support Adam and the work he's doing here on Substack and through All Rise News. Just a reminder, Adam will be in Wisconsin next week covering the trial of Judge Hannah Dugan, who is being unfairly and, frankly, I think illegally politically prosecuted by the federal government for her role in doing what she was allowed to do as a judge, to control her courtroom when it came to ICE coming to try to detain an immigrant that was appearing in front of her courtroom. But Adam, we have a two-page order from Judge Rodney Smith down here in the Southern District of Florida concerning the grand jury records that had to do with Jeffrey Epstein. This one's interesting because it obviously doesn't have a lot of analysis to it like we do with Judge Engelmeyer, but the Epstein grand jury records in Florida are obviously something we look at very carefully, even though, again, they're not going to be voluminous and super illuminative. But as we know, that grand jury and the issues that were happening down here in the mid 2000s resulted in the sweetheart plea deal that Epstein got, the non prosecution agreement, and the fact that he only had to plead to some bullshit state crimes. And that kind of got the whole ball rolling there. But your thoughts, Adam, about this order granting motion to unseal?
It to your point, Katie, both times that we've seen a ruling on the grand jury matter in the Southern District of Florida, it's been threadbare. The first one is a flat denial. This was a flat granting of it. And we'll see. There could be something interesting, perhaps, there, given all the controversy about the investigation, that what was known, in the thing that is different about the Southern District of Florida grand jury investigation and the Southern District of New York grand jury investigations is that SDNY led to charges. It led to both of these cases. So it's not a story of what went wrong. So the Southern District of Florida does not give us too many guideposts as to what to expect, if anything, from that hunt for grand jury records. It does not. It's the only of the three judges that did not take a swipe at Trump's DOJ for A, sidelining the victims, B, overstating what would be in the grand jury records. So it's more of an unknown what's happening in the Southern District of Florida, and we'll see what happens.
In the interest of full disclosure, as always, I have known Judge Rodney Smith for a good portion of my professional career. We used to be assistant state attorneys together in the Miami-Dade County State Attorney's Office. We worked together for many years. He became a state court judge and then got appointed to the federal bench and has been sitting in the Southern District of Florida federal bench for a number of years now. To Adam's well taken point, both Judge Smith and I think it was Judge Rosenberg. I think or was it Judge Rosenberg? I think Robin was it? I don't remember.
I
One of the
believe so.
yeah. They have not entered super lengthy or detailed orders down here because frankly there really wasn't a lot to, work with. Really the information I think that we would all deserve and should get would come from, being able to have more follow-up on Alex Acosta. We know he's already sat for one deposition closed door. We've seen the transcript. From House Oversight, and House Oversight said, and I spoke to Robert Garcia about this, Congressman Garcia, Adam, that, they need Acosta to come back in light of all the stuff that's coming out, right? Like
Mhm.
these are the things. Ghislaine Maxwell obviously is somebody who has been evading sitting for her deposition. And then James Comer is obviously not pushing that envelope either. All this claims of invocation of Fifth Amendment privilege, et cetera. And that's why she can't sit, which is bullshit. And a whole bunch of things. There are people that actually were for those of you that are Hamilton fans, that were in the room when it happened, and they would be
Mm,
the people that would have most of this information, not some FBI agent who sits and just answers leading questions. Although Lindsay Halligan couldn't even pull that shit off in the Eastern District of Virginia with an FBI
true.
agent. Adam, where can people find you, follow you, and show you support, especially as you venture off into the frozen tundra, I suspect, of Wisconsin?
Thank you so much, Katie. Well, if you're watching live via YouTube right now, there's that top left corner where you can find both Katie and my Substacks. If you click on that, you will find Katie Phang's Substack and mine at All Rise News. If you become a paid subscriber, you send me off to Milwaukee, Wisconsin for the trial of Hannah Dugan and all the other trials that I cover. And you can find, yeah, and you can find both of us actually on the Midas Touch Network on YouTube.
Yeah, so I'm thrilled. I also am a partner with the Midas Touch Network. I am at Katie Phang News on YouTube. I am in an end of year 2025 push to get to 500,000 subscribers. It's a free subscription, people. So if you haven't subscribed to Katie Phang News on YouTube, I would love the support. I do the longer form work that I'm doing here at Substack. I write here at Substack as well. And any support we can get for both Adam and myself, we are now independent media, independent journalists. Your financial support actually is it's pretty profound. You would be surprised. We are grateful always, even for any of your support and for tuning in. Adam is the kind of person that truly is my go-to. Adam has gone to cover Kilmar Abrego Garcia as well. So Adam is incredibly humble. I am not for Adam. Please support him in the hard work that he is doing. He is one of the most invaluable assets and resources that I can rely upon today as somebody who brings you the news and the legal analysis as it happens. Adam, my friend, I'm grateful. Thank you all also for tuning in and letting us do this kind of fun, different, whatever Meshuggah kind of Mishigas that we just did right now on desktop Substack. I feel like Adam, they should give us a bump at Substack for pushing this desktop shit. But
Yeah.
good to see all of you, and I'll see you all soon. Adam will be joining me next week to check in from the Dugan trial, so we'll be doing some live stuff as well around Adam's schedule next week when he covers this trial. Alrighty, guys, good to see you. Bye, Adam.
Bye bye. Thank you so much, Katie.
Bye, guys.